Now, let's look at the mandated regulatory areas of the Dignity Act. The 4 areas of the Dignity Act that will be regulated under the law are as follows: Policies and District Code of Conduct, Dignity Act Coordinator and Staff Training, the area of student instruction, the area of incident reporting, and the subsequent disciplinary and non-disciplinary responses. Under district policies, we will review the purpose of the district policy and policy versus policy and administrative regulations. Policies vary from district to district, such as Dasa-inspired policies, student harassment policies, employment harassment policies, no work harassment, sexual harassment policy, equal opportunity policies, the code of conduct policy, and hazing policies. Dasa policies must include Dasa definitions, prohibitions of bullying, discrimination, and harassment, guidelines to be used in school training programs to discourage the development of discrimination or harassment. Dasa policies, procedures, and guidelines must be designed to raise awareness and sensitivity to potential acts of harassment, bullying, and/or discrimination. They must promote a safe and supportive school climate and include concepts in curriculum and classroom management. Boards of education, which currently adopt and provide for the enforcement of a written code of conduct, will amend these to include the language of the Dignity Act. Additionally, approved codes of conduct will be posted on the district's website unless the district does not maintain a website, and a plain language summary in age-appropriate language will be provided to all students. Codes of conduct must include Dasa definitions, an age-appropriate version of the anti-harassment discrimination policy, disciplinary measures to be taken when harassment occurs, provisions for responding to acts of bullying, discrimination, and harassment. Codes of conduct must also include a Bill of Rights for students, reporting requirements, guidelines on promoting a safe, supportive school climate, and including such concepts in the curriculum and classroom management techniques, and various non-disciplinary remedial measures, and we must consider possible extracurricular codes of conduct. Codes of conduct must be posted on the internet website of the school or school district. They must be summarized and provided to all students in an age-appropriate version, written in plain language, at a general school assembly to be held at the beginning of each school year. They must be summarized and mailed to all persons in parental relation to students before the beginning of each school year and be available upon request. They must be provided to each teacher with any amendments to the code as soon as practical and available for review. They must be provided to each teacher with any amendments to the code as soon as possible and available for review. Codes of conduct must be subject to at least one public hearing that provide for participation of school personnel, parents, students, and any other interested party before changes can be adopted. One duty of the Dignity Act coordinators will be to handle human relations. The district must designate Dignity Act coordinators. The Dignity Act coordinator must be thoroughly trained to handle human relations in the area of Dasa's protected categories, and be employed by such school district and be licensed and/or certified as a classroom teacher, school counselor, school psychologist, school nurse, school social worker, school administrator or supervisor, or superintendent of schools. The school board must appoint a Dignity Act coordinator for each school building. The Dignity Act coordinator contact information and the school building represented by that Dignity Act coordinator must be shared with all school personnel, students, and parents by being inserted into the Code of Conduct and by posting on the district website with updates as necessary. The Dignity Act coordinator contact information must be shared with parents at least once per school year by mailing or by some other method. In addition, the information should be posted in highly visible areas of all school buildings. The district must make such information available at the district and school level administrative offices. The Dignity Act coordinator's name, contact information, and the school building represented must also be shared either by including such information in the plain language summary of the Code of Conduct provided to all persons in parental relation to students before the beginning of each school year, or by providing such information to parents and persons in parental relation at least once per school year in a manner as determined by the school, including, but not limited to, being administered through electronic communication and or by sending in such information home with students. Accessibility of the Dignity Act coordinator in each building is vital and mandated under the law. Dignity Act coordinators must be available to students, parents, and staff, and they must be available Monday through Friday. The following tasks are the responsibilities by law of the Dignity Act coordinator: that of investigating complaints, leading professional development in Dasa-related areas, helping targets of bullying with accommodations to make them feel safe, implementing positive alternatives for students who harass, and playing various roles depending on what the school environment needs. The Dignity Act requires reporting of incidents involving bullying and harassment. Any person having reasonable cause to believe that a student has been subjected to discrimination or harassment must act reasonably and in good faith. They must report. Every district should implement internal reporting procedures. Every district must comply with statewide reporting procedures when material incidents of bullying, harassment, and discrimination occur. The best advice given is to document, document, document by forms, files, notebooks, or by electronic means. Internal reporting procedures should identify the principal or principal's designee, or the superintendent or superintendent's designee as that school's particular employee charged with receiving reports. Internal reporting procedures should also enable students and parents to make an oral or written report of harassment, bullying, or discrimination to teachers, administrators, or any other school personnel that the school district deems appropriate. 2 rules mandate the timeline for reporting: the 1-day oral reporting rule and the 2-day written reporting rule. As for the 1-day oral reporting rule, the law states that any employee who witnesses harassment, bullying, or discrimination, or receives an oral or written report of such conduct, must orally notify the employee charged with receiving reports no later than 1 school day after witnessing or receiving such information. The 2-day written reporting rule reads as follows: an employee who witnesses harassment, bullying, or discrimination, or receives an oral or written report of such conduct, must file a written report with the principal, superintendent, or the principal or superintendent's designee, such as the Dignity Act coordinator, no later than 2 school days after making their oral report. The principal, superintendent, or the principal's or superintendent's designee must lead or supervise the thorough investigation of all reports of harassment, bullying, and discrimination, and they must ensure that such investigation is completed promptly after receipt of any written reports that are made. Our responsibility under the law is to take action, eliminate, prevent, and end this issue in our schools. When an investigation reveals harassment, bullying, or discrimination took place, the school must take prompt actions reasonably calculated to end the harassment, bullying, or discrimination. The school must eliminate any hostile environment and create a more positive school culture and climate. The school must act to prevent reoccurrence of the behavior and ensure the safety of the student or students against whom such harassment, bullying, or discrimination was directed. Dasa also prohibits retaliation against any individual who, in good faith, reports or assists in the investigation of harassment, bullying, or discrimination. Another note in regards to internal reporting is that a principal must make a regular report on data and trends related to harassment, bullying, and discrimination to the superintendent. On the other hand, the Dignity Act has additional requirements or mandates with regards to external reporting. The principal, superintendent, or the principal's or superintendent's designee must notify promptly the appropriate law enforcement agency when he or she believes that any harassment, bullying, or discrimination constituted criminal conduct. In the case where a district has a student resource officer, they can also include the SRO in the law enforcement reporting process. Under New York State Penal Law 240.26, harassment in the second degree is defined in this way. A person is guilty of harassment in the second degree when they, with intent to harass, annoy or alarm another person, and or when he or she strikes, shoves, kicks, or otherwise subjects another person to physical contact, or attempts to or threatens to do the same, or he or she follows a person in or about a public place or places, or he or she engages in a course of conduct or repeatedly commits acts which alarm or seriously annoy such other person and which serve no legitimate purpose. Harassment in the second degree is a violation. We must consider another external reporting responsibility that the Dignity Act impacts. With regards to material incidents of harassment and discrimination, schools must submit to the Commissioner an annual report of all material incidents of discrimination and or harassment that occurred in such school year. This report shall be submitted in a manner prescribed by the Commissioner on or before the reporting deadline for the Basic Educational Data System, or BEDS, or such other date as determined by the Commissioner. A school district must include in its annual report all material incidents of discrimination and or harassment that are the result of the investigation of a written or oral complaint made to the school principal or other school administrator responsible for school discipline or to any other employee, or incidents that are otherwise directly observed or perceived by such principal or administrator or by any other employee, regardless of whether a complaint is made. Reports must include the bias involved, actual or perceived race, color, weight or physical appearance, national origin, ethnic group, religion, religious practice, disability, sexual orientation, gender, sex, or other. They must include whether the incident resulted from student and/or employee conduct. And they must include whether the incident involved physical contact and/or verbal threats, intimidation, or abuse, and must include what the location was where the incident occurred, on school property, at a school function, or off zone. To ensure compliance with reporting procedures, the details seen on this slide represent a checklist or guide, a means to proceed to the end. Reporting follow-through is crucial, regardless of whether a student makes an allegation directly to the Dignity Act coordinator or to another school employee. All allegations must be investigated and appropriately respond to in the same manner as all other infractions of the Code of Conduct and in accordance with any or all other applicable school and/or district policies and procedures. The next two slides represent a sample reporting form that many districts have used or modified in paper form or have attached as a link on their district website, so as to make it available to students and parents. The district may provide the privilege for the report to be made anonymously. A district has the liability to format their reporting form to fit their reporting protocol, but care should be given to collect all information needed to conduct a thorough investigation so that the victim will feel as safe as possible. As well, the process should result in mitigating an end to the harassment by the instigator or bully. Consider the aspect of potential liability involved in cases involving harassment or bullying. There is no enforcement mechanism in the Dignity for All Students Act, but it creates a duty. We must ask ourselves, what is our duty toward our students? From the legal standpoint, the answer is in the Latin phrase in loco parentis, which means in place of a parent. We must ask ourselves what happens if we breach that duty. We must ask, what is negligence? Negligence would be defined as a breach of duty toward an individual that proximately causes an injury, physical, emotional, or otherwise. If negligence can be proven, the district may be sued. Of further note, districts in consultation with their attorneys can also consider non-punitive options when addressing problematic off-campus behavior such as cyberbullying. Additionally, districts and BOCES and charter schools should not fail to prevent or address in-school harassment simply because the involved students are also experiencing harassment outside of the school.